Judge Nanda.
Uh, Thank you for the time, and I'm indebted to the organizer for this privilege to speak in your presence. Uh, but at the outset, permit me or pardon me, perhaps, to begin not with law but with love, because had it not been you, people like you, had it not been people like Dr. Murali, my teacher, had it not been for your nurturing, mothering, then perhaps I, once confined in a juvenile home as a child in conflict with law, uh, may never have reached this space to adventure with dignity. Uh, while I'm not sure if I have fully reformed, I still cultivate a confusion about the politics of law. When the JJ Act itself acknowledges that a child in conflict with law is essentially a child who is also a neglected one, either by the parents or parents' patri, then I fail to comprehend why it confines the child instead of correcting the neglect, if not punishing it. In this background, since I am asked to speak on the how the promise of dignity interface at the grassroots level, I will not go into the detail as my friend has already spoken in detail about the day-to-day work, but I will try to put lights into why the situation the way it is. And to begin with, uh, let me invoke another contradiction, which are fundamental but that has repercussions which are beyond the purview of law. For example, the doctrine of ignorance, that is, ignorance of law is not an excuse. The widely accepted, but and even which is prevalent since the origin of law itself. But uh, the repercussion of it when it interacts with another fundamental doctrines of procedural law, there is audi ultum partem, that promise for a fair hearing. And when we see it from the lens of Section 12 of Legal Services Authority Act, which provides for the category of people, those who are entitled for free legal aid. And if you make a simple calculation of the categories, then you will find that almost more than 90% of the population of India, as per Section 12, are in need of legal aid and awareness. So you mentioned about the playing games without knowing roles. So I mean, as a presiding officer, when I compare it with as a referee of a football match where 90% of the player do not understand the rules, a batsman getting out, imagine, or a bowler celebrating just because the umpire raised hand without knowing why. So this is how the day-to-day work in the court. Uh, this is how the day-to-day work in the court is carried out. So here I want to ask a question. While most of our talk and deliberation are confined to the 10% who knows the law, so when you talk about rule of law, is it rule of law or is it the rule? Those who know the law. So from here, I want to give one insight which we all know from the field, but not very often theorized. That is, that much before the trial began, in fact, it is about setting the criminal law into motion. As you know, there is no principle of locus standi because the violation of the penal code itself victimized the people and the republic as a whole. But I want to ask, who actually set the criminal law into motion? It is always the victim who has suffered harm in terms of injury to his body, mind, reputation, or property is again burdened further to travel to the police station and file the case. The next important question is, which is directly related to the replication of the doctrine of ignorance and the efficacy of the doctrine of odi ultum partem, is who scribed the FIR. And a clinical survey or review reveals that though the procedural law says that the SHO should write it, but in fact it is most of the FIRs are written by people who are beyond the reach of law, either retired police officers or advocate clerks or even semi-professional lekhankar, those who are popularly called. So when a lekhankar writes an FIR, it removes the agency of the victim. He introduced his own bias into it, and his knowledge of official language, not law. Whereas when an SHO writes it, he is the senior-most official of a police station who face cross-examination in the court on a daily basis. That's why the law expects him to apply the fact into the provision of law. But when a lekhankar writes it, and there is a rate chart unofficially that in fact the rate chart is directly proportional to the mens rea and the offense involved. For example, if the offense is variable, let's say they will charge some 100 or 200 rupees. If the offense is non-valuable and if it's session tribal, then the rate will increase. And these lekhankars or ghost of FIR writers, I say them, are in fact beyond the clutch of law. So what this suggests is about the grassroots of law is a reminder that the root is not native, it is imported, rather it is imposed. So from this, when I try to understand that the history of this root of law, you see, from the Vedic system of exclusion to the Victoria rule of Victoria, and beginning with Plato's Republic to Aristotle politics, and even be that Augustine's original scene or the secularization of it by Thomas Hobbes in the name of state of nature, and even the Kant's categorical imperative or Hegel's realism, absolute realism, or Marx materialism, to the Bentham's pain and pleasure. What they do and what is common in them is all proposes one universal order with utter disregard and disrespect to the diversity and dignity of the people. Here I want to ask a question on behalf of the 90% of people, that can we imagine dignity, or can we imagine coexistence of dignity with dependency? Because if we see the colonial history of India, which is in fact an illustration of this, one or singular universal order, then you see that law was used as an instrument of perpetuating cruelty and loyalty. For example, while the Criminal Tribes Act and the Forest Dwellers Act, Permanent Settlement Act impose cruelty by making people criminal by birth, by making forest dwellers homeless, and by making wandering sovereign bonded labor, and the pre-trial detentions that confine people without even a promise of trial. It all imposed cruelty. Whereas on the other hand, the law also nurtured loyalty, by conferring titles to the local princes, gun salutes, privileges, signing channels with local rulers. So this culture of cruelty and loyalty defined the history of colonialism in India, which, in my opinion, the Indian Independence Act, the Indian Independence Movement, the freedom movement, was also an endeavor, an endeavor against arbitrariness and absolutism, which was culminated into the Constitution. And I see the Constitution of India as a rupture of this colonial culture of cruelty and legality, loyalty. How is it in rupture? Is in Article 17, it criminalized cruelty by not only abolishing untouchability, but also, you know, uh, uh, by making it an offense. In Article 18, it abolished titles. So thereby it reversed the order. Before the Constitution came, against the law, if against the law, an adventure with dignity was that we had only one option, that is to resistance violence, which was itself a exclusion, a form of automatic exclusion. But after Constitution came into force through Ambedkar, it gave a third path. That is how I refer Article 17 and 18. But it was not automatic. As you know, Article 372, legitimized the continuity of colonial laws, and Article 13, on the other hand, put a filtration that pre-colonial laws, those are not in consonance with the Constitution. Application of them is void ab initio. So, the last 75 years of the constitutionalism, in fact, I sum it up as a conflict between the continuity of law on the one hand and a constitutionalization of it, or a due of its constitutionalization. So before I go into discuss some of the more field-based experience, I must here bring that in the last 75 years, the contention between Article 372 and Article 13, that while, in the first 3 decades of constitutionalism, Parliament, took credit of bringing some landmark reforms and thereby even curtailing the jurisdiction of court and thereby limiting the scope of participation of people in the process. But until 1974, the CRPC came, the pre-colonial laws and policy remain in force. The judicial magistrate, despite having Article 50 that speaks about separation of executive from judiciary, remain within the control of district magistrate, who was also the head of police. It was only in the 1973 CRPC that judicial magistrate was made independent, which came into force after the latter part of 1970s, when Supreme Court in fact recognized the right to dignified life as a fundamental right under Article 21. So this is where I understand when in the last few decades the Supreme Court has went on even acknowledging the rights, but even fixing accountability not only on the police but also on the magistrate, judicial magistrate, while using discretion in judgment like Anesh Kumar, Satinder Kumar until, while guiding the use of discretion, how it fails to translate at the grassroots level is because while the Supreme Court took about 30 years to realize the constitutional aspirations, I believe the trial courts are yet to reach there. In this background, I want to bring the latest case discussed by my former Chief Justice, who about the Sukanya Santa case and the constitutional transformative potential of the Indian Constitution. In that respect, when I look into this judgment from the lens of a trial court judge, how I see it is Article 17 as a constitutional crime is not only available against the state but also against the individual. But it remains in force for 75 years. And when after 75 years, it was identified and acknowledged that the prison rules that provides for division of labor based on caste is a violation of Article 17, and in fact is a constitutional crime. It only pass an order of conviction without sentence, without even naming those who are the violators of Article 17. So it's when you see it from the perspective of dignity on trial, a warrant that remain unexecuted for 75 years, in fact, reduce Article 17 into a moral code. Why I refer to this is because it speaks, on the other hand, the reality of the working of the trial code at the ground level. When we see that in the prison, majority of population are from SC, ST, and people belonging to backward class, then we see that this continuity of law or constitutionalization of it. I am uh, I'll bring the our discuss topic of bail and remand and bail jurisprudence. I believe that it is not only about the liberty that the bail is discussed with such intensity, but also it is because of the stigma that society attaches to it when someone visits the jail. Why I say so? Because it is equally important whether someone is inside the jail or on bail. The liberty is conditioned until the end of the trial. One is bound to appear on each date of posting of a case, and if not physically, through an advocate with the permission of the court. So, when we limit the scope of Article 21, person in custody, and the scope of speedy trial only to those who are in the custody, we undermine the conditioning of liberty of lakhs of people, those who are on bail. And the other aspect of bail is, again, the consequences of the conflict between the continuity of law and the constitutionalization of it. Because historically, we know that most of the people belonging to SC, ST, and marginalized people had never owned property. Even if they had land, they did not have document. So when the financial system of bail expects them to, a property-based bail system expects them to provide furnished security or surety to, enjoy the conditional liberty, then it goes beyond the purview of law. Sometimes while they stay inside the jail despite being granted bail, sometimes the whole family is victimized. They are pushed into forced labor and migration, which are not even within the scope of law. Then another point, a contradiction with which I will end.
Sorry, Judge Nanda, you have 3 more minutes.
Okay,
Just to tell you.
Yes.
Thank you. I'm sorry about that.
So the last contradiction that I will bring maybe is while in the last 75 years, the Supreme Court has in fact passed many landmarks judgment guiding the discretion at the ground level and constitutionalizing the, colonial and pre-colonial legislations. How do you see the recently, enacted BNS, Bharatiya Nyaya Sanhita, that replaced IPC, which in fact replaced the penal with Nyaya or justice, but in content, it enhanced the punishment. It over-criminalized certain behaviors. So here I ask a question, if BNS equates justice with punishment and followed by another, that if the purpose of a penal law, substantive law is punitive, how much justice can we expect from the procedural law? Because we know that the object of procedural law is to execute the mandate of substantive law. So yes, I will stop here with one line that we all are either product of cruelty or loyalty, but the third path that Constitution gives is of to live a life with dignity. And I want to ask a question to everyone that when Article 13 says that pre-colonial laws cannot be applied and it declares it void ab initio, shall we wait for the Supreme Court or the higher court when the definition of Article 12 includes all the institution of governance as under the definition of the state? Is it not an obligation of all the citizen and all the institution of governance to automatically not apply those laws because they are void ab initio? Thank you.
Thank, thank you, Judge Nanda. You bring up a point that hasn't been touched up to now, is that if the colonial laws and the substantive laws are indeed punitive and do not stand up to constitutional scrutiny, then is there a duty cast upon judges and also ordinary citizens, perhaps, to do something about it, academics and those? I don't think you could just throw them off the books, but Vidhi has just done a really, really good study on crime and punishment. 7,200 laws which have in them, to some degree or other, punishments. And some of them are extremely absurd. You know, like one of them I remember is not adequately walking your dog may lead to penal consequences. So one of the things that Vidhi is advocating for and should have your attention is depenalizing, decriminalizing. At the same time, you have the BNSS or the new laws, which have actually increased some of the punishable acts, and in many others, they have also decriminalized some, but in many others, they have actually created mandatory sentences or longer sentences. Now, what is this going to do to the jails, and what kind of burden is it going to put on the magistracy? Only another year or two will see. In regard to bail, there is what you have said, Judge, and what you have adverted to, Judge Nanda, is very much the problem, and the solution to it at the moment has been just a sort of band-aid that we will create a fund for the most vulnerable and we will pay their bail or stand surety, which seems to be a bit circular. The state is asking somebody to appear and make a condition for appearance, but then the state is paying for that. But if he doesn't appear, then the state will pay the state for the state to do something. It's a bit roundabout, but if somebody else can explain it to me, I'm full of it. I'm so happy about it.